Yeah, we're starting with that. And there's actually, we're going to play this too. I need to make sure that it's paused. Okay. Morning, Jamie.
Oh, the stream is on.
Oh yeah, we're up. It's that time, baby. You go ahead and hit the thing. And good morning.
Good morning.
How you doing today?
I'm great. This first day of Black History Month.
It is the first day of
It's Black History Month again.
Again.
Hey, and I can make a prediction. Next year, for Black History Month, we could talk about the first black female Supreme Court justice.
Yeah. You mean Kamala? I know it's not going to happen, but you best to believe that the DNC has already batted about the idea. You know, if we appoint Kamala, then we can get her off the ticket. 'Cause, buddy, they are begging for a reason to get her off the ticket.
You know, and the ironic thing is it's Kamala usually getting other people off that got her where she is.
Like, for example, on the ticket.
Have you seen?
We've got other stuff to talk about. We don't need to dwell too long on Justice Spit Roast.
Have you seen the meme of Hillary Clinton in blackface?
Yes.
I hear y'all are looking for a Supreme Court justice.
But yeah, let's open Black History Month by talking a little bit about how Joe Biden is just actively pandering, and I mean what he's doing by saying I will only consider black women for the Supreme Court nomination. That's a crime. For him to say that out loud is illegal, right? Now, we've talked about this in the past. We're free speech absolutists. But, and normally I would say if you say I'm a free speech absolutist, but, then you're not a free speech absolutist. But this is one where it's not the speech itself that's a crime. The speech itself, however, is an admission of guilt in the premeditation of the commission of a crime. And that crime, of course, is discriminating in hiring practices by a federal agent based on the list of hierarchies, in this case, sex and race. So it is not, in fact, a crime for Joe Biden to say that he will only consider a black woman for the nomination. But if he only considers black women for the nomination, that is an action, and that is itself a crime.
And I'm gonna take the radical view and say I don't even necessarily think that should be a crime. Like, Austin Peterson said something once in a debate, and it really, really resonated with me. No, please make it easy for the bigots to self-identify so it's easy for me to not do business with them.
Okay, so I'm with you there, but this is a different scenario. In this case, we're talking about fair treatment under the law.
I realize it's different when a federal official does it than a private business. It just...
But I'm 100% with Peterson there. You know, absolutely. If the bakers, if the deli doesn't want to serve pork because it's a Jewish deli,
I don't have to eat there.
I don't. Well, or I can go there and buy not pork. Right? Or I can say, I refuse to do business with you because I like pork. And hey, I want to know that up front. And sometimes what I want is a Reuben, and that's beef.
And sometimes what I want is a Cuban.
Sometimes what I want is a Cuban. And frankly, there's a lot of things that I'll do business with Jews for. But a Cuban, I need somebody from the island. Not that island. I'm looking for something a little less spicy and a little more pickly. But, I mean, come on, guy.
Yeah. Oh,
And Steve's right. The Bakers won the case, and they absolutely should have. Like, that was an open and shut case.
Yeah, but
kind of like the Ahamaud Arberry case.
Yeah, but it still destroyed their life, though.
It did.
Yeah. Oh, yeah.
It did. And that's a whole nother bucket of worms. So, you guys saw the thumbnail. Obviously, we're going to be talking about the extension of the McMichaels and Arberry case here in a minute. And it's going to get a little dark.
Extension.
Yes, and that's an important piece of that information. So
they already have life sentences, y'all.
Yeah, leave them alone.
Like,
you've murdered them enough.
I mean,
have you that the McMichaels are facing any additional legal jeopardy is itself a gross miscarriage of justice. But we'll get back to that in a minute. Let's get on something fun for a minute. This could be a little segment. Maybe we'll cut this out and publish it separately because Twitter had some fun this morning. And good God. Fair warning. For the next several minutes, I recommend heartily against the drinking of coffee. You won't hear me say this often. I recommend that you do not attempt to drink your coffee for the next several minutes. Here we go. Oh, and she says, Amy opens with, this is a real thing that happened on the twitter.com and I'm screaming. Justin Trudeau. This morning I tested positive for COVID-19. I'm feeling fine and I'll continue to work remotely this week while following public health guidelines. Everyone please get vaccinated and boosted. Justin Trudeau, who is now positive for COVID-19, by the way, is
after
triple vaxxed and
I was about to say, hadn't he been like...
He's had all of them. And here's Dr. David Samadi. Sometimes having COVID makes you feel like you just got hit by a truck.
Hey, and you know why it's okay to talk about Justin Trudeau on February 1st?
Blackface?
Yeah, well, because we
Prime Minister Blackface?
We started talking about,
and
Black History Month.
He gave us this, he does have this public announcement. We're gonna let him speak because it's fair to give a little time, a little
Hello,
listen
everyone.
Oh my.
I hope y'all were ready for that one. So,
boy, he is the definition of the word foppish.
Yes.
Like,
yes, he is.
Like, if you have testosterone in your body, you just want to punch him in the face. Like, for his own good. No, toughen up. Toughen the hell up.
Yeah,
what's wrong with you?
You'd be doing him a favor.
You know, like, there's a certain type of effeminate that, like, Prince was. Prince was that way by choice, and he knew it. Trudeau is just yikes. Anyhow, okay. The actual...
Okay. So, we're going to start, as much as I frickin' hate to do it, and I would love to be done talking about this case, we're going to relitigate the Arbery case very briefly. Brief highlights. These are the things that you need to know about this case. The first thing I want to share with you is if you Google, or in our case, DuckDuckGo, Ahamaud Arberry, these are the images you see. You'll notice it's just the same image repeated over and over again. There's two shots, right? They've got two shots that make him look like a decent, clean-cut young man. But you need to understand that this is what the internet, the BLM DNC controlled narrative internet wants you to see, is this clean-cut, nice-looking young man. But you must never forget that this is the person we're talking about.
Bruh, you can't touch me, bruh. Don't touch my car and don't touch me.
I'm not touching your car.
Don't touch
I'm looking
me,
inside of your car.
Don't touch me. You can't.
The person we're talking about is one with a violent criminal record, whose criminal record includes evading, assaulting, and fighting police. And yeah, Alex, we're going to get to that.
We're going to get to that, Alex. Yeah,
that's a very serious miscarriage by itself, right there, because it's kind of like the pleading the fifth thing, but we'll get to that in just a second. So when we talk about Arbery, it's important to understand that in the Arbery case, I don't have these in a particular order, so let me see if I can remember. Okay, here's where we are. In the Arbery case, it's important to remember that the judge ordered that Arbery's criminal history be excluded from the evidence in the trial. Now, there's a good case to be made for that in many trials, but not in all trials. What you need to understand, the defendant's attorney, Robert Rubin, pointed out that Arbery was even known as the jogger due to his pattern of dashing into convenience stores, stealing, and running away. In addition to this, Arbery was on probation for 2 crimes. The first crime due to carrying a handgun onto school property. The other crime was for fleeing police. His criminal records also show 2 separate police encounters in which Arbery threatened and cursed at officers. Right? So we're talking about somebody who has a criminal history of actively doing the thing that he was suspected of doing when the McMichaels attempted to effect a citizen's arrest. The next thing you need to understand and remember about the Arbery case before we get any further into the news, the developments on this, is that before okay, I can get rid of that one. Before we even get to the Arbery case, I lost my spot. Damn. Okay, before we even get to the Arbery case itself, you need to understand that before the case went to trial, several prosecutors recused themselves from the case. After having found that the case was a clear-cut case of self-defense based on the law, which made it a clear-cut case of a citizen's arrest, which went wrong. The McMichaels are both law enforcement guys, right? One of them was a cop, and one of them was some other kind of clerk or something. But both, civil servants in the law enforcement sphere. These guys are a little different than just a civilian conducting a citizen's arrest, but at the time, a citizen's arrest under these circumstances was absolutely lawful. That's not an opinion. That is the case. And it's an important piece to make that observation here, because when we talk about this, here's from Legal Insurrection. The Arbery case trial, Judge Wamsley drops the ball on ambiguous citizen's arrest law. So what this judge did is what he should have done was taken the law and disambiguated it for the jury. He did not. Instead, he left the jury with ambiguous instructions, conflating the 2 sentences of the clause, which make it clear that there is a different standard of citizen's arrest in the case of misdemeanor and in the case of felony. Now, the suspicion held on Arbery for the execution of a citizen's arrest was that he had committed felony burglary and trespassing. The evidence shows that is the case, that's what he does. That includes video evidence of him in the act, as well as prior police reports from the homeowner listing property removed from the property, items removed from the property, tools, fishing gear, etc. Hang on. And under the law, and now we're not talking about state law now, we're talking about the law generally, right? Under the law, if a statute is ambiguous...
Okay, that's what I was going to say.
If it is unclear, then the interpretation must favor the defense. That is the law. This judge, who I want you to understand before I complete the rest of this thought, is a judge from a district 80 miles away who came in to preside after all 5 of the judges in the district where the crime was was alleged had recused themselves for similar reasons, this judge comes in, and this article says that he dropped the ball. He didn't drop the ball. This guy came in and decided that he wanted to lynch some white boys. I recognize this is a white judge. It is. I will also point out that Joe Biden is white.
We talked about it at the time, too. That is a thing that bothered the absolute hell out of me. I forget the lawyer's name who was on Timcast right around the time the judge handed down this decision. Mm-hmm. And I remember the lawyer, like, honestly, he came across as like a greasy piece of shit. And he was like, I don't care about the McMichaels. They can go to prison for all I care. What I care about is the law and how the defense works. And if there is, and the way he put it was something along the lines of, if there is gray area, it always goes to the defense. If there's a doubt,
the benefit of the doubt
goes to the defense. And even though you and I were pretty clearly in the minority on thinking about what happened with the McMichaels and thinking that this was a citizen's arrest that went bad, there was enough people that were in the minority, like you and I, where there was some possibility of it. Like, there was gray area. And I'll point out, they changed the fucking law after they got
correct.
Okay,
they changed the law
if there's no gray area,
authorities and powers away from citizens.
If there's no gray area, why did you change the law?
Right.
I mean, I'm just saying. Okay?
So what happened here is a government decided to retroactively criminalize actions which were not criminal at the time of their activities. They decided, you know what? We don't like what these guys did, so we're going to make it a crime back then. You can't do that.
Yeah, and look, it's not that you could think the McMichaels are pieces of shit. You could think the McMichaels are responsible for Arbery's death. I could even see a case where...
Hey, Zimmerman was a piece of shit, but it was clear-cut self-defense.
I don't know that Zimmerman started out as a piece of shit.
Yeah, he did.
Well, anyhow...
But being a piece of shit doesn't mean you don't have lawful rights.
Well, and it could have even been... It could have even been that they were guilty of manslaughter, involuntarily causing the death of another human being. But felony murder, all right? Murder is like, there's only a few crimes where you can't get, like, aggravated sexual battery and murder. There's a few crimes where you get no leeway whatsoever. Right. And murder is one of those crimes.
Well, and Stryker points out they don't want people protecting their community. See Rittenhouse.
Exactly.
You're absolutely right. A big part of this is you peons will sit there and suffer, and you will tolerate being violated and murdered unless you employ the government authority on your own behalf. Never mind that they are wholly inadequate to the task and not even required by duty of oath or law to prevent or intercede or stop crimes in progress. See Gonzalez v. Castle Rock. Never mind that when seconds matter, the police don't care. Never mind any of that. Right, and the statute is actually quite clear. Let's read the actual statute. It's actually pretty clear. To say that it's ambiguous is a miscarriage of justice. Where's the, here it is. These are the two sentences of the statute right here. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony, and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So here's what I read, and this is what this lawyer goes on to explain as well, is that normally, under normal conditions with a basic crime, a misdemeanor, and we have to assume, this is where the ambiguity comes in, we have to assume that the first sentence refers to the commission of a misdemeanor, because the second sentence, even though it doesn't mention misdemeanor explicitly, because the second sentence mentions felony and holds you to a lower bar to intercede in the case of a felony. So that, with that in mind, the first sentence, necessarily applying to misdemeanor, says that you may arrest an offender if the offense is committed in your presence or within your immediate knowledge, right? And then the second sentence says, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So in the first case, you need absolute certainty.
You have to see me steal the bag of chips.
That a misdemeanor has been committed, and then you may commit you may conduct a citizen's arrest.
In the second
case, if it's a felony,
if you're pretty sure I stole a gun but didn't see me do it.
So and this guy describes it later, but I don't want to go searching for it. Basically, the judge's interpretation is that if it's a felony, you must have certain knowledge in order to effect an arrest, and then you must also be 51% certain that the crime committed. That doesn't make any sense. If you've already met the high bar of certainty, then there's no use here for there to be a lower bar to meet in the case of more serious crimes. What this clearly is supposed to do is, when you're talking about petty theft, petty larceny, shoplifting, misdemeanors, then before you detain someone and call the police to incarcerate or prosecute them, you must be certain that they committed the offense. But if you're talking about a murderer fleeing the scene who is thereafter likely to get away with the murder, because the murder solve rate in this country is below 50% nationally. It's statistically 0% in Rockdale County, by the way. So the point is that if it's the much more serious crime, for example, murder, right, and they're clearly going to get away.
Felony burglary, Alex.
And Alex, that is not a problem.
Look,
Alex, no, stop. Alex, that's not a problem that they had. Not only did the defense argue that the felony was felony burglary, the prosecution stipulated to that and admitted to it. That was never in contention or controversy in the trial. It was never a question of whether or not there was reasonable suspicion that he had committed felony burglary. That's not a problem the defense had. The prosecution granted that, admitted to it. So that was not a problem in this case.
And they only had to have reasonable suspicion.
Correct.
Like, that was the
reasonable and probable grounds of suspicion.
And they had pretty reasonable suspicion that that's what was going on. But look, we're coming down to the end, and I'm trying to nudge you over toward the hate crime portion of it.
Right. So I'm going to switch this back over to this camera because I don't remember where I put the thing. I didn't even get to Joyette Holmes, but we're going to skip over her and get back. Okay. So I've got one from Fox News and one from CNN, neither of whom are your friends.
By the way.
And okay, and this is the last time I'm going to address you on this, Alex, and then we're going to get to this. Alex says there was no evidence submitted that showed burglary, no video showed burglary. They didn't need to submit any evidence on that because the prosecution stipulated to it without evidence. Since the prosecution stipulated to that without evidence, it no longer needed to be proved. It was agreed upon. But the evidence exists. We've seen the evidence. But once the prosecution stipulated to it, they didn't need to present evidence because they didn't have to argue it.
Well, and again, they had to have reasonable suspicion, which they had.
Right. Okay, so Ahamaud Arbery's mother feels completely betrayed by DOJ's hate crimes plea deal. That there is a hate crimes plea deal to be made. Here's where we get to serious, even more serious miscarriage of justice. The McMichaels have been convicted of murder.
Yeah.
Now, wrongfully convicted. But the fact is, they have been convicted. And now, they're going after them for federal hate crimes charges. So before we get down there, hate crimes. We've already broken the F-bomb barrier on this episode.
Yeah, that was my fault.
Fuck you. There is no such thing as a hate crime. Murder is murder. When you start slapping the hate crime label on there, what you are saying is that because of your immutable characteristics, we have determined that the immutable characteristics of your victim make you a more heinous murderer. The only hate crime is the application of the label hate crime. Because what you are doing with the application of the label hate crime in any crime is you are making a determination about a person being guilty, which is a state that is not subject to gradation under the law. And you are saying that this person is more guilty because of their immutable characteristics. I cannot think of a thing that is more racist than saying that a person is extra guilty based on the color of their skin. That's insane. And that's where we begin this pickle. So, there are federal hate crime charges for the McMichaels to plea on to begin with is a serious miscarriage of justice.
I mean, and it's double jeopardy, and it's the federal government, okay? Like, if you went back and you told the founding fathers, hey, guess what? The federal government is going to be able to sail in behind the state governments and try people for crimes, they'd all looked at you like you were crazy. This is a thing, and especially over a form of speech or opinion. Okay, so we covered no such thing as a hate crime, and then double jeopardy. And here's the deal, okay? I personally think this is being done for two reasons. There's the show aspect of it.
Yep.
And then there is the fact that if the McMichaels and Roddy Bryan win an appeal, they can go free. But look, y'all, all right, I heard a lawyer say it this way, and this is important to understand, okay? Appeals are for losers. And it's just a fact.
That's one of those hard truths.
All right? Like, and even if they win an appeal, they'll be there for at least 5 years.
Yeah.
Like, okay, and then they're going to carry the stigma for the rest of their life. Like, they're screwed. And
these men are already ruined. Their lives are over.
Right. Like, you win. You win. Okay.
But to make the PC to make the PC people feel extra shiny, they want their lives to be over.
And so what had happened here, in brief, because we're coming up on the end, is that Travis McMichael had worked out a plea deal where he'd get moved to a federal facility. And look, there's probably a legit safety concern in play.
Yeah.
Okay? Like, I would not be surprised if Travis McMichael dies of old age. And in fact, no, what I'm trying to say is I will be surprised if Travis McMichael dies of old age in prison.
Right.
Okay? I mean, I'll be very, very, very surprised. So, Ahmaud Arbery's mother comes out, makes the big statement. And so, I can't believe they would do this. I feel so betrayed. So the state or the federal government is rejecting a plea deal. All right, now going back to that whole appeal thing, you can't really appeal a plea deal. If you voluntarily plead guilty, it's almost impossible to get that overturned because you voluntarily pled guilty. So the defense and the district attorney here, or the prosecutor, I don't know if it's a district attorney at the federal level, worked out a deal where they plead guilty and move them to a federal facility and would basically guarantee that they'd be in prison for at least 30 years because then you can't fucking appeal it, right? And no. Instead, we're going to reject that, make them go through the double jeopardy. And I can honestly say this, at least I'm intellectually consistent. Remember when I was like, I'm really uncomfortable with the feds just sailing in and undoing the Juicy Smollett deal?
Yeah.
And I don't like Juicy Smollett. I think he's a piece of shit. In fact, you could even argue...
But he made a deal.
But he made a deal. And you could even argue that possibly if there's a such thing as a hate crime, man, he hated him some Trump supporters enough to fake an attack by Trump supporters. And look, I don't want Jussie Smollett to be charged with a hate crime. I don't want anybody to be charged with a hate crime. All right? Nobody. But if it's good for the goose, it should be good for the gander. And the fact that we're just going to come in, we're going to undo the deal that these guys were going to make, and now they've got till Friday to decide if they're still going to if they're going to withdraw their guilty plea or not. I don't know. Like, and what happened here is the judge just decided, like, this was all worked out. In fact, this almost never happens.
Right.
Okay?
What happened here is the plea deal was worked out, and then Arbery's mother, Wanda Cooper Jones, who I would like to point out does not share his last name, and I'm sure that has nothing at all to do with his advanced criminal career. She basically begged the judge, and the judge said, okay, cool. Because what she wants is for them to spend their time in the more dangerous and less comfortable state prison, or to get a heavier, more painful sentence from the federal prison. Basically, they're going to be looking at going through the double jeopardy situation on the federal hate crimes charges, because this criminal's mother wants to hurt them more than they have already been hurt, which, let's remind you, is life in prison without the probability of parole. As a result of technically lawful activity. Now look, let me remind you, I haven't even said that what they did was a good idea. Right? But it was lawful. And that's an important distinction.
And I just really want to stress this point, too. It is so rare for the defense and the prosecution to work out a deal. Like, because the defense attorney and the prosecuting attorney, they're all officers of the court. And judges take that into consideration. Yes. A judge says, okay, if two people with law degrees can come to a mutually agreeable outcome to the disposition of this case, that is probably in the interest of justice. If the defendant is represented and the state is represented and they both agree that this is a satisfactory compromise, there you go. There you go.
So let me put a button on this.
But the judge decided in this one case, oh no. And why? For the cameras.
Let me put a button on this. This is why this matters, and then I got to button this up because I got to get down the road and fly some drones.
Hate crimes are beautiful legislation. Yeah. Simply opposing them makes you racist.
I'm going to give you that one.
So these unconstitutional laws will remain intact permanently.
So, yeah, Stryker, that's a good point. The vast majority of people sworn to the bar do have law degrees, but you can take the bar and be sworn to it without a law degree. That is possible and lawful. But here's what we're looking at. This is why it's so frustrating. From the get-go, multiple prosecutors looked at the evidence in the McMichaels case and said, nope, this is a clear-cut case of self-defense in the course of a lawful citizen's arrest. When attempting to conduct a lawful citizen's arrest, the proposed detainee assaulted the citizens and attempted to wrestle their weapons away from them, and then one of the firearms discharged in that altercation. There's not even reasonable evidence that Travis McMichael intentionally fired the weapon. Right? And so multiple prosecutors said very clearly this was clear-cut. These men are not guilty of murder. We're not even going to prosecute this. And then they were terrorized, harangued, and assaulted by mobs of racist rioters until they recused themselves. And it happened more than once. It was either 3 or 4 different prosecutors. And then they went to the other side of the frickin' world to find an Alpha Kappa Alpha, right? You've got Joyette Holmes, who is listed as a Republican DA, but this woman is a member of Alpha Kappa Alpha. That is a black women's sorority that is actively involved in progressive, racist activism. That is the organization that she belongs to. And she's been a member of that longer than she's been pretending to be a Republican. And she swept in and said, I'll hang me some white boys. Let me get some of that. And then 5 judges recused themselves in the same community where the crime was committed under similar threats and terrorism by BLM and DNC activists. And after all of that, you get a judge that comes in and intentionally drops the ball on a clearly fallacious and intentionally fallacious misinterpretation of a very clear law, deciding that he's going to require that the bar described in the law be raised at his discretion rather than within the confines of the law, and then drops ambiguous jury instructions, leaving the jury to muddle through the ambiguity of the law rather than, as a jury is supposed to do, muddle through the ambiguity of the facts to straighten them out in accordance with the law. So you have an absolute railroad joke of a prosecution and a trial that leads these 3 men to an illegitimate murder conviction, and then, in subservience to the terrorism of Black Lives Matters, they're going to elevate this crime to a federal hate crime with more severe penalties, placing these men in double jeopardy on a crime that they have already been convicted of after the fact.
You might have, Demography Now is pointing out this is a joke. The fact that they changed the citizens arrest law is basically an admission that they were acting with. I made that
Correct.
point earlier in the show. You might have just not been here. I won't tell anybody that you were late.
I will.
But I think that's about a ball game.
Yeah, that's all we got for today. Y'all be safe out there, and we will see you tomorrow.